I installed a wheelchair ramp for my disabled 10-year-old daughter Leah and came home to find a $600 HOA violation notice taped to our door. Karen Whitlow, our HOA president, called it an unauthorized modification and demanded we remove our daughter's only way to access her own home. I'm Daniel Pierce, 41 years old, and I work as a freelance contractor specializing in accessibility modifications. My wife Melanie is the district attorney for Fairfax County, Virginia. Our daughter Leah is 10 years old, brilliant, artistic, and has used a wheelchair since a spinal injury 3 years ago when a drunk driver ran a red light and changed our lives forever. We live in Willow Bend Park, an upscale gated community that prides itself on pristine appearance and strict adherence to community standards. When we moved here 5 years ago, it seemed like the perfect place to raise a family. The houses were beautiful, the neighbors seemed friendly, and the schools were excellent. Then Leah had her accident, and we learned what our perfect community really thought about families like ours. The trouble started after Leah's latest spinal surgery. Her doctor recommended a new wheelchair ramp design that would give her better independence accessing our front door. As a contractor, I knew exactly what she needed: a gentle slope with proper handrails and a non-slip surface that would blend seamlessly with our home's architecture. I spent 2 weeks building the ramp myself, using materials that matched our house perfectly. The design was elegant, functional, and completely compliant with ADA standards. Every morning I watched Leah's face light up as she rolled up that ramp independently, no longer needing me to carry her up the front steps. "Dad, look! I can race you to the door now!" she'd giggle, her wheels spinning as she propelled herself forward. "I don't know, kiddo," I'd reply with mock seriousness. "You might be too fast for this old man." Those moments of pure joy made every hour I'd spent building that ramp worth it. Leah was finally feeling independent in her own home, confident and happy. That's when Karen Whitlow decided to remind us who really controlled our neighborhood. The violation notice was waiting for me when I got home from picking up Leah from physical therapy. Bright yellow paper, official HOA letterhead, signed by Karen herself in her characteristic heavy black ink. Community Standards Violation, case hash 2024-0847, property 1247 Maple Ridge Court Violation, unauthorized external modification description, installation of permanent ramp structure without HOA approval. Fine, $600 action required, submit. Architectural review application with plans, fees, and timeline for compliance review. Timeline, 15 days for initial response, pending board approval. I stared at the notice in disbelief, reading it 3 times to make sure I understood correctly. We'd installed a wheelchair ramp for our disabled daughter, and the HOA was treating it like we'd built an illegal addition. Leah rolled up beside me in her wheelchair, her backpack still slung over her shoulder from school, art supplies poking out of the top. She'd been working on a painting of our house that included her new ramp, colored in bright purple and yellow. "What's that, Dad? You look upset?" "Just some paperwork from the HOA, sweetheart. Nothing for you to worry about." But Leah could read the tension in my voice. She'd become very good at picking up on adult concerns since her accident. Too good for a 10-year-old. "Is it about my ramp?" Her voice got smaller. "Did I do something wrong?" My heart broke a little. "No, baby. You didn't do anything wrong. The ramp is perfect and you're perfect. Some of the neighbors just have questions about it." "Questions like what?" I knelt down beside her wheelchair so we were at eye level. "Adult stuff. Boring rules and paperwork. I'll work it out, okay? Promise. Promise." But even as I said it, I could see the worry creeping into her eyes. Leah had developed an acute sensitivity to being seen as a burden ever since her accident. Any suggestion that her needs were causing problems would devastate her. The next morning, I called the HOA office to discuss the violation notice. The secretary, a sweet elderly woman named Mrs. Patterson, transferred me directly to Karen Whitlow, who answered in her characteristic tone of barely concealed irritation. "Mr. Pierce, I assume you're calling about your compliance issue." "I'm calling about the ramp I built for my disabled daughter. It's a medical accommodation." "Medical accommodations still require architectural review and board approval, Mr. Pierce. You can't just modify your property without following proper procedures." "Karen, it's a wheelchair ramp. My daughter needs it to access her own home." "Mr. Pierce, everyone thinks their situation is special. The Henderson family thought their pool deck was special. The Johnsons thought their gazebo was special. If we made exceptions for every personal circumstance, we'd have chaos. This isn't a gazebo. It's medical equipment. It's a permanent structural modification that affects the aesthetic integrity of our community. The architectural review process exists for everyone's benefit. I could feel my frustration building. How long does architectural review take? Typically 6 to 8 weeks for initial review, then 2 to 4 weeks for board consideration. If modifications are required to meet our standards, the timeline extends accordingly. You want my daughter to wait 3 months to access her front door? I want your family to follow the same rules as everyone else. The ramp can stay during the review process, but if it's not approved in its current form, it'll need to be removed or modified to meet community standards. What community standards? It's ADA compliant and matches our house perfectly. Community standards are determined by the Architectural Review Board, not federal regulations. We maintain certain aesthetic requirements that preserve property values for all residents. I took a deep breath, trying to stay calm. Karen, this is a medical accommodation for a disabled child. Mr. Pierce, I understand you're emotional about your daughter's situation, but personal circumstances don't override community covenants. The process is clearly outlined in your HOA agreement. Emotional? My daughter can't walk upstairs. And I'm very sorry about that, but feelings don't trump legal obligations. The process is the process. After hanging up, I sat in my kitchen feeling helpless and furious. How could anyone be so callous about a disabled child's needs? But I decided to try a different approach. Maybe if Karen met Leah and understood her situation, she'd be more reasonable about the accommodation. That afternoon, I was working in the garage when I heard voices outside. Through the window, I saw Karen talking to Leah by our mailbox. My daughter was in her wheelchair, holding a drawing she'd made in art class, a picture of our family standing together in front of our house, with her ramp prominently featured in bright purple. I stepped outside to listen, staying close enough to hear but not immediately visible. "What's that you're drawing, sweetheart?" Karen was saying in a voice that dripped with false sweetness. "It's my family in front of our house. See? That's my ramp. I painted it purple because purple is my favorite color." "Well, isn't that interesting? You know, honey, this isn't a hospital. We don't usually allow permanent eyesores that make the neighborhood look institutional." Leah's face crumpled, confusion replacing the excitement she'd shown about her artwork. "Eyesore? But it's just so I can get in my house. I'm sure your parents can find a more appropriate solution. Maybe something that's not so visible, something that doesn't affect how our whole neighborhood looks. But I need the ramp. I can't walk up the stairs. There are other ways to handle these situations without affecting the whole community's property values, sweetheart. Maybe your parents could build something in the back of the house where people can't see it." "The back? But then I can't use the front door like everyone else." "Well, sometimes we have to make adjustments based on our circumstances." I stepped out of the garage, my blood boiling. "Karen, what are you doing?" She turned with her practiced smile, but I could see the cold calculation in her eyes. "Just explaining community standards to your daughter. Children need to understand how neighborhoods work. She's 10 years old enough to learn about rules and responsibilities, old enough to understand that we all have to make sacrifices for the greater good." Leah rolled her wheelchair toward the house, her drawing clutched against her chest. I could see tears starting to form in her eyes. "Daddy, do I make the neighborhood ugly?" "No, baby. You make everything more beautiful." "But Mrs. Whitlow said—" "Mrs. Whitlow was wrong. Go inside and wash up for dinner, okay?" As Leah disappeared into the house, I turned back to Karen. "Don't ever talk to my daughter about this again. Any issues with the ramp, you discuss with me or my wife." "Mr. Pierce, community standards affect everyone, including children. If she's going to live here, she needs to understand how we maintain our property values. She's a disabled child who needs a ramp to access her home. She's a resident who needs to understand that her personal needs can't override community welfare. The sooner she learns that lesson, the easier her life will be. Her life would be easier if people like you showed basic human decency." Karen's fake smile disappeared entirely. "Mr. Pierce, I suggest you adjust your attitude. This community has standards, and if your family can't meet them, Perhaps you should consider whether this is the right place for you. Are you threatening us? I'm explaining reality. Some communities are better equipped to handle special situations like yours. That evening, Leah barely touched her dinner. She'd stopped working on her art projects and spent most of the evening sitting quietly in her room, staring out the window at her ramp. "Daddy," she said when I tucked her in, "is my ramp really ugly?" "No, sweetheart. It's beautiful and functional and it helps you be independent. But Mrs. Whitlow said it makes the neighborhood look like a hospital." I sat on the edge of her bed, my heart breaking. Mrs. Whitlow is wrong about a lot of things. Maybe she's right. Maybe we should move somewhere else where I won't cause problems. Leah, look at me. You don't cause problems. You're smart and funny and artistic and perfect exactly as you are. But what if the other neighbors think my ramp is ugly too? Then they're wrong too, and we'll figure it out together, okay? Okay, Daddy. I love you. I love you too, kiddo. More than all the stars in the sky. When Melanie got home from a late court session, I told her about Karen's conversation with Leah. My wife had built her career prosecuting people who abused power, and I could see the familiar look in her eyes when she encountered injustice. She said what to our daughter? Called the ramp an eyesore, suggested we move if we can't meet community standards. Melanie's jaw tightened. She'd grown up with a disabled brother and had zero tolerance for disability discrimination. "Where's the violation notice?" I handed her the yellow paper. She read it twice, then walked to her home office and closed the door. I could hear her voice through the walls, making phone calls in the clipped, professional tone she used when building legal cases. The next morning brought another HOA notice, this one delivered by Tracy Boone, Karen's enforcer who handled the dirty work of intimidating residents. Tracy was a thin, nervous woman in her 50s who seemed to enjoy delivering bad news to neighbors. HOA compliance update. Case hash 2024-0847 violation status. Escalated new fine assessment. Additional $300. Total $900. Reason: failure to submit architectural review application. Community impact. Multiple neighbor complaints regarding aesthetic. Disruption required action. Immediate submission of removal timeline or compliance plan. Timeline: 7 days for response or further enforcement action will be initiated. Note: continued non-compliance may result in legal action and forced removal of unauthorized structures. But that wasn't the worst part. Tracy had taken photos of our ramp from multiple angles and posted them in the community Facebook group with the caption, "This is what happens when we ignore rules. Property values suffer when standards slip." The comments were brutal. Neighbors I'd thought were friends called the ramp an eyesore and a precedent we can't allow. Some suggested we should move to a more appropriate community for our situation. Mrs. Henderson from 3 houses down wrote, "I feel bad for the family, but we can't let emotions override property values." Tom Bradley, who I'd helped with his deck construction the previous summer, commented, "Maybe they could build something less visible in the backyard." Sarah Kim, whose kids played with Leah before the accident, posted, "There are communities designed for special needs families. This might not be the right fit." The most hurtful comment came from Janet Walsh, who lived directly across from us. "My realtor says visible medical equipment can drop property values by 15 to 20%. We need to think about everyone's investment." Leah saw the Facebook post before I could stop her. She was checking the community page because she liked seeing photos of neighborhood pets. But instead, she found dozens of neighbors discussing her ramp like it was a contamination that needed to be removed. She spent the afternoon crying in her closet, convinced that she was the problem, that her disability was ruining things for everyone. "Daddy," she sobbed when I found her curled up between her winter coats, "everyone hates my ramp." "They don't hate it, baby. They just don't understand. Mrs. Walsh says I make everyone's houses worth less money. Maybe I should ask God to make me walk again so nobody has to look at my ugly ramp." I pulled her out of the closet and held her while she cried. "Leah, listen to me. There is nothing ugly about you or your ramp. Some people are scared of things that are different, but that's their problem, not yours." "But what if they're right? What if I really am ruining everything?" "You're not ruining anything. You're making our family stronger and our neighborhood more inclusive." "What does inclusive mean?" It means a place where everyone belongs, no matter what they need to be happy and healthy. That evening, I found a note she'd left on her art desk. Maybe I should ask God to make me walk so nobody has to look at my ramp. I'm sorry for causing problems. Love, Leah. When Melanie came home and found Leah hiding in the closet again, something fundamental shifted in my wife's demeanor. She spent an hour comforting our daughter, reading her stories and reminding her how loved and wanted she was. Then she walked calmly to her office and began making phone calls. First call. This is District Attorney Melanie Pierce. I need to speak with someone about filing an ADA compliance complaint. Yes, I'll hold. Second call. Janet, it's Mel Pierce. I need a referral for your best civil rights attorney who specializes in housing discrimination. No, this isn't for a case, it's personal. Third call. Cynthia, it's Melanie. I need you to do some investigative work for me. Private pay, highest priority. The Willow Bend Park HOA. I want everything. Financial records, previous complaints, board member backgrounds, everything. When she finished, I asked what she was planning. Justice, she said simply. First civil, then criminal, then personal. Mel, it's an HOA dispute. Maybe we should just go through their process, pay the fine, get the approval. Daniel, they made our daughter feel ashamed of needing a wheelchair. They posted photos of her medical accommodation online to shame our family. They're targeting a disabled child to make a point about property values. I know, but maybe if we... No, this isn't about a ramp anymore. This is about a systematic pattern of discrimination, and I'm going to prove it. What do you mean? I mean, Karen Whitlow just declared war on the wrong family. She's about to learn the difference between having authority over an HOA and having the power of the state behind you. The state? I'm the chief prosecutor for this county. I have resources Karen can't even imagine. Investigators, forensic accountants, civil rights attorneys, federal contacts. She wants to bully a disabled child. She's about to discover what happens when you pick on someone whose mother spent 15 years sending bullies to prison. The steel in Melanie's voice reminded me why she'd never lost a major case. When my wife decided to destroy someone, she was methodical, thorough, and utterly relentless. What's the first step? Documentation. Cynthia is going to find every family they've targeted, every violation they've issued, every discriminatory action they've taken. I'm going to build a pattern of civil rights violations that will make federal prosecutors salivate. And then? Then I'm going to systematically dismantle Karen Whitlow's little kingdom, piece by piece, until she understands that power comes with consequences. The next week, Cynthia's investigation began revealing the scope of Karen's discrimination. She found 4 previous cases where the HOA had targeted families with disabled members. The Martinez family was fined $1,200 for installing grab bars that were visible from the street. Their 8-year-old son had cerebral palsy and needed the bars to safely navigate their front steps. Elderly residents George and Linda Chen received violations for using a medical alert system because the emergency button on their front door was aesthetically disruptive to the neighborhood's clean lines. The Williams family was forced to remove their teenage son's wheelchair lift because it altered the garage's architectural integrity. Their son Marcus had muscular dystrophy and couldn't access the family car without the lift. The Johnson family was cited for excessive medical equipment storage when their daughter Emma's physical therapy equipment was visible through their front window. Emma had spina bifida and needed daily therapy. In every case, Karen had used architectural review requirements and aesthetic standards to make life unbearable for families dealing with disabilities. Some families had paid thousands in fines rather than fight. Others had moved away rather than continue the battle. But none of those families had a district attorney for a mother. It's worse than we thought, Cynthia reported during a meeting in Melanie's office. I've found 17 families that moved away after HOA conflicts involving disability accommodations. Karen has been systematically purging the community of anyone who doesn't fit her vision of aesthetic perfection. 17 families? I couldn't believe it. Karen keeps detailed records. She actually tracks what she calls visual disruptions in a spreadsheet. Wheelchair ramps, medical equipment, adaptive vehicles. She documents everything and uses it to target families. Melanie leaned forward. What kind of documentation? Photos, violation histories, even notes about which families are problematic for property values. She's created a systematic discrimination machine disguised as HOA enforcement. That's federal civil rights territory. It gets worse. The families that stayed and fought, she escalated harassment until they either complied completely or left. The Williams family spent $8,000 fighting violations before they finally moved to a different state. What about financial records? That's where it gets really interesting. The HOA has spent over $200,000 in legal fees fighting disability accommodations in the past 5 years. But here's the kicker. Karen's brother owns the construction company they force residents to use for approved modifications. Melanie's eyes lit up. Self-dealing? Every time a family needs accessibility modifications, they're required to hire Whitlow Construction at inflated rates. Karen has been personally profiting from the discrimination she enforces. That's fraud. How much are we talking about? Based on the contracts I found, at least $400,000 over 4 years. Families pay premium rates for HOA-approved accessibility work, and Karen gets a kickback from her brother. So she discriminates against disabled families, forces them to use her brother's company, then pockets the profits while pretending to enforce community standards. Exactly. And if families refuse to use Whitlow Construction, she escalates violations until they move away. Melanie's first legal move was surgical. She filed a temporary restraining order against the HOA board, citing Americans with Disabilities Act violations, Fair Housing Act discrimination, intentional infliction of emotional distress against a minor child, harassment and retaliation for asserting civil rights. The restraining order immediately stopped any enforcement action against our ramp and required the HOA to preserve all documents related to disability accommodations. Karen's response was swift and furious. She called an emergency board meeting that evening and issued a statement to the community. The Pierce family is using their daughter's condition to manipulate the legal system and avoid following rules that apply to everyone else. This frivolous lawsuit threatens the very foundation of our community standards. We will fight this attack on our authority and protect the property values that benefit all residents. The statement was posted on the community website and sent to every household. Karen was trying to turn the community against us by framing our civil rights complaint as an attack on everyone's financial interests. But Melanie wasn't finished. Her next move was pure genius. She scheduled a press conference on the sidewalk outside our house, with Leah beside her in her wheelchair. Local news crews arrived within an hour. The story of an HOA targeting a disabled child's wheelchair ramp was exactly the kind of David and Goliath narrative that captured public attention. "My name is Melanie Pierce, and I'm the district attorney for Fairfax County," she began, speaking directly to the cameras. "I'm here today not as a prosecutor, but as the mother of a 10-year-old girl who was told that her wheelchair ramp makes our neighborhood look like a hospital." The camera panned to Leah, who sat quietly in her wheelchair wearing her favorite purple dress. She looked small and vulnerable, but also dignified and strong. "This beautiful ramp behind me allows my daughter to access her own front door independently. It was built by her father with love and care, using materials that perfectly match our home. It's elegant, functional, and completely compliant with federal accessibility standards." Melanie's voice got stronger as she continued. "But according to our HOA president, this ramp is an eyesore that makes our neighborhood look institutional. She told my daughter that there are other communities better equipped to handle special situations like ours." The lead reporter, Sarah Martinez from Channel 7, stepped forward. "Mrs. Pierce, what specific actions has the HOA taken?" "They've fined us $900 for installing medical equipment that our daughter needs to access her home. They've posted photos of our ramp online to shame our family. And they've given us 7 days to remove it or face forced removal. How has this affected your daughter?" Melanie looked at Leah, who nodded slightly. They'd practiced this moment. "Leah, can you tell everyone why your ramp is important to you?" Leah looked up at the cameras with the serious expression she wore when discussing important things. "My ramp helps me get into my house by myself. Before I had it, Daddy had to carry me up the stairs every day. Now I can race him to the front door." "How did you feel when Mrs. Whitlow called it ugly?" "Sad. And like maybe I didn't belong in our neighborhood because I use a wheelchair." "Do you think you belong here?" "My mom says I do, and I think all kids should be able to get into their houses." Sarah Martinez wiped her eyes. Even the camera operator was visibly moved. Mrs. Pierce, is this an isolated incident? Absolutely not. This isn't about one ramp. It's about a systematic pattern of discrimination against families with disabled members. The Willowbend Park HOA has been using architectural standards as a weapon against some of our community's most vulnerable residents. What evidence do you have of this pattern? 17 families with disabled members have been forced to move from this community in the past 5 years. Every single family that's requested reasonable accommodations has faced escalating harassment until they either paid excessive fines or left the neighborhood entirely. What do you want to see happen? I want my daughter to grow up in a community that values inclusion over aesthetics. I want other families to know that civil rights aren't negotiable just because you live in an HOA. And I want the people responsible for this discrimination to face appropriate consequences. The story went viral within hours. HOA targets disabled girls' wheelchair ramp appeared on national news networks. The footage of Leah calmly explaining why she needed her ramp, contrasted with the HOA's harsh violation notices, created a public relations nightmare for Karen. The community response was swift and divided. Residents who'd been silent about Karen's authoritarian tactics began speaking out. Anonymous tips flooded into Cynthia's investigation. Audio recordings of Karen mocking wheelchair users as property value killers during board meetings. Documentation of secret fines issued to elderly and disabled homeowners for medical equipment violations. Evidence that Tracy Boone had threatened residents behind on dues with enforcement escalation. Email chains where Karen discussed strategies for encouraging voluntary relocation of problematic families. Financial records showing the relationship between the HOA and Whitlow Construction. But not everyone supported us. A counter-movement emerged, led by neighbors who worried that our lawsuit would eliminate all community standards. Janet Walsh organized a petition supporting the HOA. While we sympathize with the Pierce family's situation, we cannot allow emotional appeals to override the legal obligations that protect our property values. If we make exceptions to architectural standards, where does it end? Tom Bradley posted on Facebook, I feel terrible for Leah, but the HOA has a responsibility to all residents, not just one family. There has to be a middle ground that doesn't involve lawyers and media attention. The Hendersons, who lived next door to us, were more direct. This used to be a quiet, peaceful community. Now we have news trucks and protesters. The Pierce family has turned a simple permit issue into a circus. But for every neighbor who criticized us, 2 more came forward with stories of Karen's abuse. Mrs. Chen, the elderly woman who'd been cited for her medical alert button, knocked on our door with tears in her eyes. Thank you, she said simply. I've been afraid to leave my house since Karen started targeting me. I thought I was the only one. Marcus Williams, the teenager who'd lost his wheelchair lift, called from his new home in Maryland. She destroyed our family, he told Melanie. My parents spent everything they had fighting her, and we lost anyway. I had to finish high school in a different state because of that woman. Emma Johnson's mother, Susan, drove over from their new apartment across town. Karen made Emma feel like she was broken and shameful, Susan explained. A 15-year-old girl with spina bifida was made to feel guilty for needing physical therapy equipment. Emma still has nightmares about being different. Each story strengthened Melanie's resolve and added evidence to our growing case. Meanwhile, Karen was doubling down on her position. She hired an expensive public relations firm and began a media campaign portraying herself as a defender of community standards against frivolous lawsuits. The Pierce family wants special treatment that would destroy the very principles that make our community desirable, she told Channel 7. If we eliminate architectural standards for emotional reasons, we'll see property values collapse and chaos replace order. But this is a wheelchair ramp for a disabled child. It's an unauthorized structural modification that violates community covenants. The law is the law, regardless of personal circumstances. Do you think it's appropriate to target a 10-year-old? I've never targeted anyone. I've enforced the rules that every resident agreed to follow. The Pierce family signed the same covenants as everyone else. What about families who say you've systematically discriminated against disabled residents? Those are false accusations from disgruntled former residents who couldn't follow basic community standards. We have a responsibility to all our residents, not just the vocal minority who want exceptions to every rule. Judge Myra Halpern ordered an emergency hearing after discovering Karen had tampered with HOA meeting minutes to hide discrimination. Complaints. Your Honor, Melanie argued, defendants are destroying evidence. We need immediate preservation orders. Karen's nervous attorney tried minimizing. This is a simple contract dispute over architectural standards. Mr. Finch, I see 17 families with disabled members forced to leave. That's civil rights violation, not contract dispute, Judge Halpern replied, granting injunctions protecting our ramp. The night before our hearing, someone sabotaged our ramp. Loosened handrails, scratched surfaces, spray-painted "Follow the Rules" in red paint, and left a note. Your brat doesn't belong here. Leah saw the damage and cried. Daddy, why do they hate me so much? They don't hate you, baby. They're scared people who don't know kindness. Police found Tracy's fingerprints on our mailbox, Karen's on our door. Both were arrested for vandalism and witness intimidation. At the main hearing, Melanie systematically destroyed the HOA's defense, ADA violations. Architectural review doesn't trump federal disability law. A wheelchair ramp is the most basic accommodation. Selective enforcement. They approved decorative pergolas and patios without review, but fine a disabled child's ramp $900. Harassment. They posted photos of her medical equipment online, told her she doesn't belong, and vandalized her ramp. Financial fraud. Karen's brother owns the required construction company. She profits from the discrimination she enforces. Your Honor, the defendants claim this ramp is a tripping hazard and aesthetic violation. I'd like to present Exhibit 47. The exhibit was an email chain where Karen had written, "That ramp makes the whole neighborhood look like a rehab clinic. We need to maintain standards that keep property values high, not accommodate every sob story that moves in here." Another email, sent to her brother, was even more damaging. "The Pierce kids' ramp is perfect for our business model. Make them tear it down, then charge $15,000 to rebuild it to community standards. Easy money." Judge Halpern's expression darkened as she read the emails. "Mrs. Whitlow, did you write these words?" Karen's attorney whispered frantically in her ear before she answered. "Your Honor, my client's private communications were taken out of context. The context appears to be profiting from discrimination against disabled children. Mrs. Whitlow, I'm asking you directly. Did you write that your community should not accommodate every sob story that moves in here?" Karen's face flushed red. "Your Honor, I was expressing legitimate concerns about property values and community standards. You called a disabled child's medical needs a sob story? I was frustrated by the legal complications. Mrs. Whitlow, yes or no? Did you conspire with your brother to force families to pay inflated rates for accessibility modifications?" Karen's lawyer tried to object, but Judge Halpern cut him off. "I'll rephrase. Mrs. Whitlow, how much money has your brother's construction company received from HOA-mandated accessibility projects?" "I don't see how that's relevant." "Answer the question." "Approximately $400,000 over 4 years. And how much of that was kicked? Back to you personally?" "Your Honor, that's a loaded question. Mrs. Whitlow, we have bank records showing regular payments from Whitlow Construction to your personal account totaling $67,000. Did you fail to disclose this financial relationship when voting on accessibility requirements?" The courtroom was silent. Karen's elaborate defense was crumbling under Melanie's methodical prosecution. "Your Honor," Karen's attorney tried to intervene, "my client invokes her Fifth Amendment right against self-incrimination." "Too late for that, counselor. Your client has been answering questions for the past hour." Judge Halpern turned back to Karen. "Mrs. Whitlow, let me ask you something simpler. Do you believe that disabled children deserve equal access to housing?" "Of course, but do you believe that aesthetic concerns should override medical necessities?" "It's not that simple. Actually, it is exactly that simple. You've been systematically discriminating against families with disabled members while profiting from that discrimination. The evidence is overwhelming." Melanie stood up. "Your Honor, I'd like to present victim impact testimony." "Proceed." The first witness was George Chen, the elderly man who'd been cited for his medical alert button. "Mrs. Whitlow made me feel like a criminal for trying to stay safe in my own home," he testified, his voice shaking with emotion. She told my wife and me that we should consider assisted living if we couldn't maintain appropriate appearances. What specific actions did she take? Fined us $300 for the alert button. Another $250 for my wife's walker being visible on our porch. When I had a heart attack last year, she complained that the ambulance was disrupting community aesthetics. How did this affect your family? We spent our retirement savings fighting her fines. We're both 83 years old, and she made us feel like we didn't belong in the home we'd lived in for 15 years. The next witness was Maria Martinez, whose son had cerebral palsy. Mrs. Whitlow told me that grab bars made our house look like a handicapped facility, Maria testified through tears. She said there were communities better suited for families like ours. How did your son react to this harassment? Diego stopped wanting to come home. He was 8 years old, and he felt like his disability was causing problems for everyone. He asked me if God made him wrong. What was the financial impact? We paid $1,200 in fines, then $8,000 to Whitlow Construction to rebuild the grab bars to community standards. The new ones were identical to what we'd installed ourselves, but we had to pay Karen's brother or face more fines. Where is your family now? We moved to Maryland. Diego said he never wanted to see Mrs. Whitlow again. The testimony continued for hours. Family after family described Karen's systematic harassment, her financial extortion, and the devastating impact on their children. But the most powerful testimony came from Leah herself. Melanie had prepared her carefully, and our daughter spoke with a clarity and dignity that silenced the courtroom. Mrs. Whitlow told me that my ramp made the neighborhood look ugly, Leah said, her small voice carrying clearly through the quiet room. She said I didn't belong here because I use a wheelchair. How did that make you feel? Melanie asked gently. Sad and ashamed. I thought maybe I was broken and ugly and that's why everyone was mad about my ramp. Do you think you're broken? My mom says I'm perfect the way I am, but Mrs. Whitlow made me feel like I was causing problems for everyone. What would you want Mrs. Whitlow to know? Leah thought carefully before answering. That kids who use wheelchairs just want to get into their houses like everyone else. And that being mean to kids is wrong, even if you're a grown-up. Do you feel safe in your neighborhood now? Not when Mrs. Whitlow is there. She looks at me like I'm something bad. Karen tried to interrupt. Your Honor, this child is being coached. Mrs. Whitlow, you will remain silent or be removed from my courtroom. When Leah finished her testimony, there wasn't a dry eye in the room except for Karen's and her attorneys. Judge Halpern's final ruling was swift and comprehensive. Permanent injunction protecting our ramp and any future accessibility modifications, $75,000 fine against the HOA for civil rights violations. Personal liability for Karen Whitlow in the amount of $25,000 for each family she'd discriminated against. Criminal referral to the Department of Justice for the construction fraud scheme, federal oversight of the Willow Bend Park HOA for 3 years. Mandatory sensitivity training for all board members. But Judge Halpern wasn't finished. Mrs. Whitlow, in 30 years on the bench, I have rarely encountered such systematic and callous discrimination. You've turned community governance into a protection racket that targets the most vulnerable residents while enriching yourself through corruption. Your Honor, I was protecting property values. You were exploiting disabled children for financial gain. You made a 10-year-old girl feel ashamed of needing a wheelchair. You destroyed families and drove them from their homes. Your actions represent everything that's wrong with unchecked authority. I was following community standards. You were violating federal law and basic human decency. Mrs. Whitlow, you are hereby permanently banned from holding any HOA position in any community. You are also referred to the Department of Justice for criminal prosecution. Karen's face went white. Criminal prosecution? Mail fraud, wire fraud, conspiracy to violate civil rights, and racketeering? The federal government takes a very dim view of people who profit from discriminating against disabled children. The criminal investigation moved quickly. Federal agents raided Karen's home and the HOA offices, seizing computers, financial records, and communication devices. What they found was worse than imagined. Karen had run a systematic discrimination scheme for over a decade, targeting disabled families, elderly residents, and single mothers she deemed undesirable. She kept spreadsheets tracking demographic improvements. Problematic families. Relocated. 23 inches. Revenue generated from enforcement, $340,000. Construction contract profits, $67,000. Her community purification strategy outlined plans to eliminate all disabled residents through escalating violations until voluntary relocation. Despite facing federal charges, Karen remained defiant. "I'm being persecuted for protecting property values." This is what happens when feelings override legal obligations. The trial was swift. Karen was found guilty on all counts: 23 civil rights violations, 17 mail fraud, 12 wire fraud, 8 conspiracy, and 6 racketeering charges. She received 15 years in federal prison plus $890,000 restitution. Tracy Boone got 18 months. During sentencing, Leah addressed Karen directly. "You tried to make me feel like I don't belong because I use a wheelchair. But I do belong there. You were the one who didn't belong because you were mean to kids who just needed help." Karen's final statement showed no remorse. "I maintained standards and protected investments. This prosecution will destroy community governance everywhere." The aftermath transformed Willowbend Park. The Martinez family returned, the Chens aged with dignity, and new policies welcomed all families regardless of disability status.